In this lecture, we would like to discuss regarding amalgamation of two or more small companies and holding company and its subsidiary company as provided under Section 233 of the Companies Act 2013, and in that connection the provisions of Section 230 and 232 are not wing applicable, and we would like to discuss this very provision in regards to amalgamation. So, as per the provisions of Section 233, a scheme of merger or amalgamation may be entered into between two or more small companies or between a holding company and its subsidiary companies, or between the holding company and its wholly owned subsidiary company, or such other class or classes of companies as may be prescribed under the Companies Act, and those conditions to be followed as regarding that we would like to discuss seven such important conditions regarding amalgamation of companies. The first one is notice for inviting objections or suggestions, and the second condition is regarding consideration and approval, and the third one relating to declaration of solvency, and the fourth one approval of the majority of the tenants, and filing of copy of approval, and the role of registrar or the official liquidator, and also finally the condition in relation to in case of objections and suggestions. So, as per the first condition, as provided under the provisions of Section 233, a condition is relating to a notice of the proposed scheme inviting objections or suggestions, if any, from the registrar and official liquidators were registered, where the registered office of the respective companies are situated, or persons affected by the scheme within 30 days is issued by the transferor company or companies and the transferee company. And as regarding the second condition, the objection and suggestion received or considered by the companies in their respective general meetings, and the scheme is approved by the respective members or class of members at a general meeting holding at least 90% of the total number of shares. And the third condition is relating to that each of the companies involved in the merger files a declaration of solvency in the prescribed form with the registrar of the place where the registered office of the company is situated. And the next condition is relating to the scheme is approved by majority representing 9/10 in value of the creditors or class of creditors of respective companies indicated in a meeting convened by the company by giving a notice of 21 days along with the scheme to its creditors for the purpose or otherwise approved in writing. And the next condition, the transferring company shall file a copy of the scheme as approved, so approved in the manner as may be prescribed with the central government register and the official liquidator where the registered office of the company is situated. And the next condition is that on the receipt of the scheme, if the registrar or the official liquidator has no objections or suggestions to the scheme, the central government shall register the same and issue a confirmation subsection thereof to the companies. And finally, if the registrar or official liquidator has any objection or suggestion, he may communicate the same in writing to the central government within a period of 30 days. So these are the conditions. And now, in regards to amalgamation and merger of companies and holding company and the subsidiary companies, will discuss the very role of National Company Law Tribunal. So, on the receipt of the application for amalgamation and merger from the central government or from any person, if the tribunal, for reasons to be recorded in writing, is of the opinion that the scheme should be considered as per the procedure laid down in Section 232 of the Companies Act, the tribunal may direct accordingly to, or it may confirm the scheme by passing such order as it deems fit, provided that if the central government does not have any objection to the scheme of amalgamation, or it does not file any application under this particular section before the tribunal, it shall be deemed that it has no objection to this scheme, and a copy of the order under this subsection 6 confirming this scheme shall be communicated to the registered having jurisdiction over the transferring company and the persons concerned, and the registrar shall register the scheme of amalgamation and issue a confirmation thereof to the companies, and such confirmation shall be communicated to the registrars where transferor company or companies were situated. The registration of this scheme under subsection 3 of section 232 or subsection 7 shall be deemed to have the effect of dissolution of the transferor company without the process of winding up. And now we would like to discuss the applicability of section 232. And in that connection, the very provision as under section 232, if the central government, after receiving the objection or suggestion or for any reason, is of the opinion that such a scheme is not in public interest or in the interest of the creditors, it may file an application before the tribunal within a period of 60 days of the receipt of the scheme of amalgamation under subsection 2 of section 233, stating its objection and requesting that the tribunal may consider the scheme. So, this is the provision in regards to application of the provision of section 233 in relating to amalgamation of companies as provided also under section 232 of the Companies Act. And now we'll discuss the very effects of registration. So, as provided under the Companies Act, so the very effects are: the first one, transfer of property or liabilities. So, transfer of property or liabilities of the transferor company to the transferee company, so that the property becomes the property of the transferee company and the liabilities become the liabilities of the transferee company. And the second effect is relating to applicability and enforceability of charges. So the charges, if any, on the property of the transferor company shall be applicable and enforceable as if the charges were on the property of the transferring company. And the third effect of registration in regards to amalgamation is continuity of proceedings. So legal proceedings were against the transferor company pending before any court of law shall be continued while or against the transferring company. And the fourth effect is relating to debts of dissenting creditors. So, where the scheme provides for purchase of shares held by the dissenting shareholders or settlement of debt due to dissenting creditors, such amount to the extent it is unfed shall become the liability of the transferring company. So a transferring company shall not, on merger or amalgamation hold any share on its own name or in the name of any trust, either on its behalf or on behalf of any of its subsidiary or associate company, and all such shares shall be cancelled or extinguished on the merger or amalgamation. Here, in regards to that, the central government may provide for the merger or amalgamation of companies in such manner as may be prescribed. And finally, company covered under this section may use the provisions of Section 232 of the Companies Act for the approval of any scheme for merger or amalgamation. And now we'll discuss the various powers of the central government as provided under Section 237 of the Companies Act in relation to amalgamation and merger in public interest. So, where the central government is satisfied that it is essential in the public interest that two or more companies should amalgamate, the central government may, via notified in the official gazette, provide for the amalgamation of those companies into a single company with such constitution, with such property, powers, rights, interests, authorities, and privileges, and with such liabilities, duties, and obligations as may be specified in the order. The order under subsection 1 of section 237 of the Companies Act also provide for the continuation by or against the transferring company of any legal proceedings pending by or against any transferor company, and such consequential, incidental, and supplemental provisions as may, in the opinion of central government, be necessary to give effect to the amalgamation scheme. So every member or creditor, including a debenture holder of each of the transferor companies before the amalgamation, shall have as nearly as may be the same interest in or rights against the transferring company as he had in the company of which he was originally a member or creditor, and in case the interest or rights of such member or creditor in or against the interest or right of transferring company are less than his interest in or rights against the original company shall be entitled to compensation to that extent which shall be assessed to such authority as may be prescribed by, and every such assessment shall be published in the official gazette, and the compensation so assessed shall be paid to the member or creditor concerned by the transferring company, and also any person aggrieved by any assessment of the compensation made by the prescribed authority under subsection 3 of section 237 of the Companies Act of 2013 may within a period of 30 days from the date of publication of such assessment in the official gazette prefer an appeal to the tribunal, and thereupon the assessment of the compensation shall be made by the tribunal. So no order shall be made under this section unless a copy of the proposed order has been sent in draft to each of the companies concerned, and so also the time for preferring an appeal under subsection 4 of section 237 of the Companies Act 2013, the time for preparing an appeal has expired, or where any such appeal has been preferred, the appeal has been finally disposed of, and the central government has considered and made such modifications, if any, in the draft order as may deem fit in the light of suggestions and objections which may be received by it from any such company within such period specified as the central government may fix in that behalf, not being less than 2 months from the date on which the copy aforesaid is received by that company, or from any class of shareholders therein, or from any creditors, or any class of creditors thereof. And finally, the copies of every order made under Section 237 of the Companies Act shall, as soon as may be after it has been made, be laid before each house of Indian Parliament. So, these are the power of the central government in regards to amalgamation and merger of companies in public interest as provided under section 237. Also it provides the very provision of publication of assessment of compensation in official gazette, and also the very provision of appeal against such assessment before the tribunal. So the Companies Act of 2013 provides regarding amalgamation and merger of two or more such small companies, and also in between the holding company and its subsidiary companies. So, this is all we found under section 233 of the Companies Act 2013, and the very conditions for such merger or amalgamations as provided under section 233 of the Act show also the role of National Company Law Tribunal in regards to merger or amalgamation of companies, and the very applicability of such provisions of amalgamation and merger as provided under Section 232 of the Act and also the very effects of registration of such merger amalgamation before the register of the place where the companies are existing. So, in that connection, we have discussed the very transfer of property or liabilities of the transferor company to the transferee company. So, also, the very applicability and enforceability of the charges of the transferor company into the transferee companies also. Any legal proceedings, if it is being continuing or pending, then it would also be transferred from the transferor company to the transferee companies also. The debts of dissenting creditors would also continue to be transferred from the transferor company to the transferee companies. And besides that, we have discussed the very power of central government in regards to merger and amalgamation of companies in public interest as provided under Section 237 of the Companies Act 2013. So, we have completed the very aspects of merger and amalgamation of two or more small companies also in between a holding company and its subsidiary companies as provided under section 233 of the Companies Act 2013 and also in relation to the power of central government as provided under section 237 of the Companies Act and in regards to such merger and amalgamation of such companies in public interest what the power central government enjoys and the very question of merger and amalgamation which is made in public interest.